The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. I also want to specifically welcome the students with us from three schools, Hartley, Melvin, Sanborn, Maharaji School, and Madrid. We're very pleased to have you with us to help celebrate Constitutional Day. I know the anniversary was actually a couple days ago, September 17th, and that's because our nation's Constitution was written, and our delegates signed it on that date in 1787, 230 years ago. And our Iowa Constitution is also celebrated in conjunction with this, and it was written 160 years ago in 1857. We celebrate these great documents because even after the passage of all of this time, they remain as relevant in our lives as ever and continue to give so much meaning to who we are and who we hope to be. They guide us forward and they build upon our common values, equality and fairness and the freedoms that we have. And they tell us as well that there's more work yet to be done. This afternoon, the first case that you will hear is particularly addressed to the Constitution issues that we celebrate today, and we are pleased that the students are here to witness the proceedings. Actually, there will be three cases in total submitted this afternoon. Those cases are State of Iowa versus Danielle Brown. The second case is Paula Tyler and Mark Alcorn versus the Department of Revenue. And the final case is Brian Maxwell versus Iowa Department of Public Safety. That last case, the Maxwell case, is now submitted to the court without an argument, and will proceed to hear the arguments in State versus Brown. Ms. Conroy, you may present your argument.
May it please the court, counsel. My name is Mary Conroy, and I represent the defendant appellant, Danielle Brown. Today, Ms. Brown asked the court to reverse her conviction for possession of controlled substance second offense because the search of her purse was outside the scope of the warrant for the premises which she was found on. It's unconstitutional under both the federal and the state constitution. Additionally, it's not authorized by Iowa Code Section 808.7, and it does not fall into one of the generally well-recognized exceptions to the warrant requirement. Here, Ms. Brown had a legitimate expectation of privacy in her purse. Therefore, the question for this court on appeal is whether the state unreasonably invaded that protected interest. As a general rule, a search warrant does authorize the search of any container on the premise that might contain the object of the search. However, the Supreme Court has also said that a search warrant for the premise does not authorize the search of an individual who is not named in the warrant, but merely happens to be at the searched premises during the execution of that warrant. That has led to other courts recognizing the special concerns that arise when an individual who is not named in the warrant and does not live there, their personal effects are searched as part of the premises warrant.
Well, if I understand the facts right, the officers had a warrant, they entered, and your client and others were located in a bedroom in the home, and then they were removed from the bedroom to a living room, handcuffed, in fact, if I have the record right. And then this purse was found, I think, in the bedroom, was it not?
That's correct, Your Honor.
All right, so this is a search looking for drugs. It's a 5:30 a.m. search. A purse is a good place to find drugs. So although you are correct, your client is not named in the warrant, but it's clear from the warrant that they were looking for evidence of drug and drug sales. So why isn't there a reasonable likelihood that this purse would contain drugs, and isn't that exactly what the warrant authorized?
I don't think so, because there's no way when the warrant was issued that they would know that my client or her personal effects would be there. And to answer your question, also, the state cannot circumvent constitutional protections by removing someone from their personal property. So here, under any of the three tests that we've talked about, when applied the possession, the notice, the special relationship test, Ms. Brown had a reasonable expectation of privacy in her purse.
What about the fact the warrant application refers to, I mean, the warrant allows search of the premises, the property, the location, as well as Jeffrey Sickles, but it refers to Eileen, his sister, another woman, as someone, and isn't there a reference that Eileen may be armed, and the police come in force, basically a SWAT team raid, because they're concerned there may be firearms there. Now, how are the police going to know whether this purse belongs to Eileen or the other woman they find?
Well, I think there's several parts to that question. First, the purse is directly in front of Ms. Brown, and if you look at the photograph taken, Ms. Sickles is not in that photograph. Second, I think there is evidence, and possibly the circumstances that Ms. Sickles might have been armed, possibly that does allow the officers to go through a purse, at least for weapons. But the marijuana in this case was found inside the purse, inside a separate small pouch that no weapon could have fit in. And so I don't think the state can justify the search of that zippered pouch on an armed or this person was dangerous justification for weapons, because it's clear no weapon could be found in that.
So when the police came in, there were 5 people smoking meth in the bedroom, right?
Well, I'm going to push back a little bit. There's 6 people in that bedroom. They say that all of them were smoking meth. There's only 2 meth pipes found in that room, so I don't see how that's possible. The officer who testified to that did not actually witness any of that. So I think, yes, there's a information in the record that Ms. Brown was present in a room where people were smoking methamphetamine.
And did
I'll agree
she
with that.
admit at the scene to being a meth user?
Yes.
Okay. Why didn't they arrest her for that?
I don't know, but they didn't.
Okay. And what kind of reasonable expectation of privacy does she have to a purse she leaves in a room where it's basically a drug den? I mean,
Well, she didn't leave the purse in the room. I think she was forced to leave the purse in the room, but she didn't voluntarily abdicate any control or responsibility for that purse.
is there evidence in the record that she was carrying or wearing the purse and then was told to remove it and leave it, or was it simply on the floor?
We don't know where it was.
Well, we have the picture, right?
We have the picture, right. We don't know where it was, as I should say. We know it's directly in front of her, on her knees, when the picture is taken, shortly after the SWAT team handcuffs them and shortly before they are moved into a separate room. And quite frankly, I don't think it matters if she was wearing the purse or not. Both of them are in her possession from a standpoint, I think, on how this court should interpret possession and how this court has interpreted possession in the past. For example, in State v. Thomas, we're talking about constructive and actual possession, and this court said that actual possession is either being found on the person, so being carried, or if there's a substantial evidence in the record that supports that in that case, contraband was on the person at one time. And so I think possession in this case should be defined similarly. There is clearly evidence that this was her purse, and that it was in her possession.
Did they find out clearly that it was her purse?
Well, I think, one, it's right next to her. We don't know and there's no testimony on where the other woman in the room is. I think, arguably, even if the other woman in the room was Miss Brown in this case, that purse would still be protected as a part of her person. But there's more evidence in here. When the officer was going through the purse, he not only found her ID, identifying her as the owner, and he also he said he found other stuff with her name on it. I think in the record he does.
Prior to uncovering the drugs, did he find the identification? Do we know the timing?
I don't think we know that for sure. But I would submit to this court, it's unreasonable to think that an officer can get around the constitutional protections by searching through a whole purse or some other object when they see a billfold, like not looking at the billfold first. I think that's completely unreasonable and not congruent with the constitutional.
Is it foreseeable that if, police are knocking at the door, some drug dealer a male might just put his gun or his drugs in a woman's purse and then figure it's off limits to a search?
I guess I don't know. Certainly that's been one of the criticisms, but I don't think it's also foreseeable that a drug dealer could put drugs or a weapon in his own pocket, and that would not be, or someone else's pocket, and that would be possession, which is the test the state advocates for, but yet they would not be able to search that person. I think if there is reason to believe or probable cause to believe that someone's purse or like a visitor's purse or person does include these items, that the officers can go and get a separate warrant. Or if there's some sort of exigency, that they can search based on, a well-recognized exception, like probable cause plus exigency.
Before they searched the purse, was everybody secured and removed from that room?
The record shows that immediately when the officers entered, they handcuffed everyone with their hands behind their back. There were 6 people in that room, and one person, the target of the search, was found upstairs. After they were handcuffed, they photographed Miss Brown, and everyone, I believe the record says they photographed people where they were, and then they took them separately out to the living room where they remained handcuffed. And
Were they guarded in the living room? There was an officer there with them?
There was an officer there with them.
The police make any inquiry before they started searching through this female's purse as to who it belonged to?
No, there's no indication in the record that they ever attempted to locate or figure out which woman that purse belonged to.
Is there any evidence that the police actually did anything to separate the purse from Ms. Brown? Other than
You mean
order
like
her
physically
from
remove it from her shoulder?
Yeah,
No. The only evidence is that they removed her
from the room.
from the room where her purse was right next to her legs.
Did she claim it was hers before it was searched?
I don't believe there's evidence of that in the record. She didn't disclaim it. That's not in the record either.
And Eileen didn't claim or disclaim it?
I think that's correct, yes.
Did she even know it was being searched, though, being in the other room?
I don't think so, no. And she certainly wasn't asked her consent to search either.
And now, in this case, we do have this kind of interesting photograph at Appendix 99. I can see the purse and I can see a lot of other stuff nearby. It looks like a pretty crowded room. But if you prevail on your argument that the test is not whether the person has the item in their actual hands or on their actual person, but is sort of a kind of all taking in all the circumstances into account situation, does it appear to be within their zone or range? Isn't that going to force law enforcement, when they execute a warrant, to always take photographs as soon as they come in, so that there aren't arguments later on about that? And does that make sense? Is that what you want to be doing?
No,
have
I
people
don't-
taking photographs when there's also issues potentially of safety?
Right, I think that is one way they might choose to proceed going forward. But I don't think there's anything like in the record or any other states that require them to take photographs. It's simply whether or not they were on notice that this object belonged to someone else. And clearly they were in this case. I guess that's the test we're advocating for as far as we're asking the court to find, to follow the notice test, not necessarily the possession test.
I guess as body cameras become more common, that maybe this will be less of an issue. You will have a better record for these kinds of suppression hearings.
Right, and there would be nothing precluding an officer from testifying where the items were found, and certainly that's what we've seen before, digital cameras. Here we believe that under any test that the court would choose to apply, the possession, the notice, the relationship test, that Ms. Brown is entitled to suppression of the evidence based on the fact that the police unreasonably invaded her privacy interests in her purse. I think the circumstances of this case show that a person who isn't necessarily connected with the premise, the cops here, I think, testify that they actually just search because they believe that that's part of the scope of the warrant. And clearly that's not the case as someone's personal effects. And this court, specifically with the Iowa Constitution, has put a strong emphasis on individual rights. And certainly it's noted that it has the sanctity of personal and private property.
Why is the notice test the best one of the various tests out there?
I suppose we advocate for it because we don't believe that possession alone is sufficient to protect people's privacy interests. And I think the easiest way to explain that is just because I have left my bag, well, it's in the other room, but just because I've left my bag and gone to set it down for convenience, by the state's definition, I wouldn't be possessing it anymore, so I've somehow let go of all my privacy rights in that bag, and so it's able to be searched according to the warrant. I don't think that's reasonable to believe that I've somehow abdicated responsibility or my control over that bag just by stepping away. I think that's not consistent with the federal constitution or the state constitution. For those reasons, Ms. Brown asked the court to reverse her conviction. Thank you.
Ms. Conroy, thank you as well. Mr. Bakke.
May it please the court, counsel. A search warrant permits the search of a premises, and that includes the containers therein. The question before the court today is, when can a visitor's container be searched? The state submits that when a container is outside that person's possession, it is subject to the warrant as it is no longer an extension of their person.
Can the police remove the person from the place where it may be in their possession and then say it's not in their possession anymore, and then we could search it?
Your Honor, I would say no. The courts that have applied this test look at the instant the officers go into a residence. So in that very moment, is it in their possession or is it not? So if the purse is on the floor on the bed and not in their possession.
But is it customary for a woman to have her purse on her body at all times, especially when they're at a friend's house?
Your Honor, of course not. And I want to clarify one point while you bring it up. The mere fact that this was a purse does not mean it cannot belong to a man. We're not going to make those assumptions that a drug dealer can't buy a purse to hide his items and it's confused police. But to the heart of your question, the purpose of this, the reason we're not allowing visitors to be searched is coming from Ybarra. And in that decision, it's the fact that they're a visitor that we are not allowing their person to be searched. So when we're not...
You know, in Jackson, we didn't allow the search of a closed backpack where there was allegedly apparent authority, and we said we're not going to buy that one.
Correct.
And And here, the officer takes the young lady out of the room, puts her in another room, she's secure, so there's no threat to the officer at that time. That purse, unless it had a bomb in it, there was no threat to the officer, and they had no reason to believe there was. What would stop the officer, as we said in Jackson, from saying, does anybody own this purse? And ask those women or those people who are in the other room. And if one of them says it's mine, I mean, that answers the question whether it's the drug dealer's purse or not.
Your Honor, the warrant changes everything. Here, we're not talking about a warrantless search. We're talking about the police already had a warrant for this premises. They were looking for drugs, weapons, many other items that could have been contained in this purse. So when police officers go and search a residence, they're naturally going to run in all sorts of kinds of containers. If a drug dealer, for example, were to go around with a label maker and start putting names on every container, it would be absurd to require a deeper inquiry for each one of those containers. The possession test applies a straightforward, clear test that police officers can apply instantaneously in the field.
Didn't they apply it when the purse was in the possession, or seems to be in the possession on this appendix page? I mean, you give me your interpretation of it. We've all stared at that picture, and there's some ambiguities. We don't know exactly when it was taken, I don't suppose, and exactly in terms of seconds. We do in terms of minutes maybe. But obviously, at the time the photo was taken, the purse is in her close proximity. Doesn't that tell us something?
Your Honor, you highlight the problem with relying on that photo. The photograph is clearly staged, or at least after the fact when she was placed in handcuffs. The problem with that is it's the defendant's burden here to show that this is not subject to the warrant.
Yeah, but doesn't that show, I mean, right, we know, I agree with you 100% on everything you said, but she's handcuffed. The purse didn't fly in there. The purse got placed there because, I mean, I'm inferring, and I want you to give me another inference, but the purse was placed there because the officers believed it was her purse.
But just as easily, Ms. Brown could have been sitting on the bed or on another side of the room, and when she was handcuffed, that's just where she happened to end up, right next to this purse. This purse just as easily could have been Eileen Sickles, or even the male subject of the
The
residence.
officers wouldn't have put Eileen Sickles' purse in close proximity to a handcuffed another person, I don't believe. I mean, would they?
I mean, I disagree to a point because there's no indication in the record that this purse was placed here intentionally. They simply made a photograph. What inferences we can make from that?
How did it get there, do you think?
As I
I mean,
said,
the handcuffed individual didn't place it there, I don't imagine. And none of the other people that are handcuffed placed it there. How'd the purse get there?
well, certainly the purse could have been there. She could have been on the other side of the room. There's a million different scenarios that.
Well,
we could
wouldn't the
say.
most likely inference be that when the SWAT team enters the room, they command people to stay where they are and not move, and then immediately put the cuffs on? So isn't it more likely than not that she was cuffed and required to stay right where she was, which was right by the purse?
Certainly to a degree. I absolutely agree that she's going to be told to be put in place. But if she's laying on the bed, they're going to say, get on the floor, and they're going to move her to a place on the floor. The problem is we're talking about possibilities here. We're not talking about something that can easily be applied.
What was the evidence on the, you have pictures of her license. What was the evidence of, did they look for the license first in the purse, or did they go right, rummage to the purse, and when they found something, went for the license? What was the testimony?
It's unclear from the record again here, and we're again run into a burden problem. It's kind of a chicken before the egg problem. Which came first, the marijuana or the license? There's no clear indication, but that's again the defendant's burden to show that the warrant did not apply to this purse. She should have gotten that testimony to say, I looked for the license or I looked for the drugs first, and this is what I found. But that's assuming that the notice test would apply. That's where we would run into those questions, and that's where we would. The state's position is that because
Shouldn't the officer look for the license first before he or she rummages through the purse?
with any container in a search, the officer's looking for the items of the search. They're looking for the drugs, the weapons, those items. They're not necessarily looking for items that are not contained within the scope of that warrant, or at least we don't want them to be. So we want them looking for those items.
The state's position, the purse was in the scope of the warrant?
I don't think there's any question here that this purse could have contained drugs, that there were items named in the
That's
warrant.
not my question. Is it the state's position that the search of this purse was in the scope of the warrant?
Because the purse was not in her possession, yes, it was within the scope of the warrant.
Ultimately, I mean, in a sense, it's sort of, this is teed up, and I guess in most cases, it's teed up as a Fourth Amendment, Article 1, Section 8 problem, but is it, I mean, is it arguably just a warrant interpretation problem? I mean, the warrant here says immediate search of the above described place and person, the person being the gentleman, not the defendant here. And what if it said immediate search of the above described place and person, including any items found on the premises except for those in the personal possession of other people? That would eliminate the ambiguity, right?
To a degree, but I disagree that it was necessary in this case. Eileen Sickles was named no less than 6 times in the application in this, and the application specifically said she was believed to have these items as well. So we're not talking where it's only one person. And under the federal precedent here, police are still allowed to look in containers that belong to other people. It's only their persons that we protect, that we give that additional protection that we're not going to allow their persons.
Well, let me ask you a few questions about that. If a person has a handbag in their hand or on their shoulder or something like that, we would agree that there's a reasonable expectation of privacy and they're protected by the Constitution.
I would
correct?
agree that's an extension of their person, yes.
Okay. And if they set it down but are in close proximity, is there any lesser expectation of privacy?
Your Honor, I disagree that we're necessarily talking about expectation of privacy here. In
Well,
every,
don't we always have to be when we're talking about the
Sorry,
Fourth
let me-
Amendment?
I'll clarify. With every item contained in the house, there certainly is an expectation of privacy. But when we have a warrant, we're allowing the officers to look in those containers and those items anyways. When it's on her person and in her possession, it's an extension of her person, and that's why we're not allowing the search to happen without an additional cause or warrant exception.
So when the purse leaves the possession, it becomes a container?
A
And the
container,
police don't have to sort of pass on and think about, well, is that someone's purse that has a reasonable expectation of privacy, or is there just a container that I can look into because I have a search warrant allowing me to search this house?
Your Honor, I would argue that it's the latter. When a container is in isolation in a residence, it's able to be searched by the police having the warrant. That's an easy test for police officers
But doesn't
to
a
apply.
purse have a certain identity to it? I mean, Ms. Conroy, when she was arguing her case, she said, well, if I had my purse and then she thought it was at council table and then, oh, I left it out in the prep room, is there any lesser expectation of privacy in her purse right now because it's out in the prep room and not at her side?
I would agree she has an expectation of privacy in that. But the difference is if the police had a warrant to search the attorney prep room right now, they should be able to look inside the containers in there, even if there's items that may belong to other people.
What's the difference between a warrant and consent? I mean, in Jackson, they had a consent to search the whole apartment. I mean, a consent is a substitute for a warrant. So, you say the warrant makes a difference, but how does it make a difference? How do you distinguish that?
Your Honor, in part, we're talking about different clauses here. We're talking about a search cannot happen unless you have a warrant, and we have that warrant. The burden shifts, everything shifts in this scenario. So we're saying that the police can look in these containers. They don't have to find additional causes to look in containers when they have a warrant for that premises and when the scope permits search of that particular item. We're not saying police officers can look in everything simply because they have a warrant, but if that container is within the scope of this warrant, where it may contain items that are named in this warrant, that's when it's permissible, unless it's in the possession of an unnamed visitor. And that's where we come and give additional protection to those people because we protect their person if they happen to be at present when a warrant was executed.
The district court upheld the search for reasons including the statute that permits police to search for their own protection. Are you still relying on that statutory argument?
Your Honor, the state would agree that we have to meet the constitutional requirement before we can get to the statute. We view the statute more as an enabling clause. It enables the constitutional warrant to be executed. So we still have to meet this test. And if this court were to adopt the possession test, as we urge, if it was not in her possession, then that container falls within the scope of the warrant, and we never get to the statutory.
We have to decide the constitutional question regardless.
Correct. And I think that would provide the most clarity to police officers so they know going forward they're doing the right thing.
Why is the possession test better than the notice test or the other alternatives?
So the possession test, two parts. First, it's most likely to be adopted by the U.S. Supreme Court in Houghton. But beyond that, it's a straightforward test that police officers and defendants alike can easily apply.
Is there a notion of constructive possession, or does it have to be actual possession?
Your Honor, I think when we get into constructive possession, that's more in the notice category. So I think if we're going to adopt constructive possession, that we're talking more about a notice test. But for the possession,
So you have to hang on, you come into a home and you have to hang on to your personal belongings or lose your expectation of privacy in the event there's a search.
it would have to be on or about, it would have to be an extension of your person. It would have to fall within that definition. When
Does about mean? I mean, I understand what on means, but
I
does
think
it?
the examples Justice Mansfield gave earlier, it's on your shoulder, it's touching you in some way. That would be the most straightforward way to apply this test.
It has to be touching you. Really?
I mean, forgive my in the moment.
Just
phrasing.
exploring, I'm exploring the edges.
Sort of
of
like
this.
the grabbable area, if we're talking about,
I wouldn't even go that far, because the idea of adopting the possession test is we're not getting into situations where gamesmanship or fraud can occur by subjects present at the warrant or by the police. It's clear it's in your possession or it's not in your possession, and therefore the warrant.
Well, Counsel, I'm hearing you articulate a different definition of actual possession than we've used in a related context. Namely, if we think about the Thomas case. Now, I wasn't in the majority on that case, but there we talked about actual possession, not necessarily at the moment of the arrest, but at some time in the recent past. And what's your justification for having a different definition of actual possession in this context than in the other Fourth Amendment context?
Certainly, and I think looking at the other courts that have applied the actual possession test, it's in the moment when the police go in. In that moment, are they possessing it? Is it an extension of their person? Because after that point, certainly the police are going to intervene and move things. But in that moment, it's clear cut. The police, it's in their possession or it's not in their possession. The warrant applies. The warrant does not apply.
In the precise term physical possession test?
Yes, Your Honor.
So that would mean if I had a computer bag, which has all kinds of privacy implications. I mean, my computer bag has my computer in it, it has lots of stuff. But you don't, if you go into a home, you don't ordinarily keep your computer bag on your shoulder. I would lose any expectation of privacy in the computer bag.
Mr. Chief Justice, with your permission. Your Honor, only if it's within the scope. So if they're looking for drugs,
In the scope of drugs, that your position would be, I take it.
yes, but that doesn't mean they can go log in your computer and look for drugs in your folders. I mean, that would go beyond the scope here. So the police are still limited in the scope. And because we ask that this court provide clarity by adopting the straightforward physical possession test. Thank you.
Counsel, thank you as well. Rebuttal argument, Ms. Conroy?
Well, first, I'd like to start off with pointing out the irony that we're arguing a conviction for possession by arguing that this item was not in her possession.
But, and I see that irony too, but this really is different. I mean, you've drawn the analogy to Thomas, but to be convicted, you need to have had control over the contraband, or it had to have been in your actual possession at either presently at the time you're arrested or at some time in the past. There has to be sufficient evidence to establish that. Whereas what we're talking about now is just when when you can exclude something from a warrant for the premises. And that seems to me a different issue. One's a Fourth Amendment issue and one's an issue of substantive criminal law, right?
Well, I think they're related, so I think clearly this item was in her possession, and I think the strict interpretation that the state's arguing for has been rejected in some cases that actually apply the possession test, for the reason that Justice Katie pointed out, that people don't lose or abdicate their constitutional protections or their privacy interests.
Of course
simply
not.
by
That's why you
setting
need a
down
warrant. Right. Of course not. That's why you have to have a warrant, because the warrant is intended to override those protections. Otherwise, they're not even in the house, right?
Right, well, and this warrant was issued without any information on this particular defendant or her being in the house. And I want to push back a little bit about the state's comment that because of Houghton, we know which way the Supreme Court is going to rule. I don't think we do. There have been other cases, other courts that have distinguished Houghton. I think there's one of the 10th Circuit, and then there's a New Mexico court case that say Houghton is based on two underlying premises, and that case deals with a car. So those underlying premises that Houghton is based on are the inherent mobility of a car and the fact that it is harder to get a search warrant, that car can just move along before the cops have time to get a search warrant. And then also it's based on the idea that an individual has a lesser protection or protection interest when they're in a vehicle. And so I don't think Houghton says that the U.S. Supreme Court is going to decide this on a possession case, on a possession test. That and three justices actually dissented, and then Justice Breyer's concurring opinion has a lot to do with the fact and circumstances in that case. So in that case, the woman, he says, was a considerable distance from her purse, and she actually disclaimed that she owned it. She only claimed ownership after the officer went through it and found her ID, which she had lied about her name. So at that point, they said it was fine because there was probable cause to search the automobile. They could search anything inside of it. So I don't think that Houghton necessarily says the U.S. Supreme Court in this case is going to apply a possession test. Further, I think that this court's decision in State v. Fleming, which is arguably a very similar situation where the defendant is arguing that the search of something, even though there was a warrant, was outside the scope of the warrant for a place that he has a reasonable expectation of privacy.
But the counsel in Fleming, he had rented a bedroom within the home. He had a lease agreement in it, and the record showed that the guy he rented it from didn't have permission to go into his bedroom. So that was just a whole area of the premises off limit. Here, she's not claiming that that was her bedroom she rented, right? She's just a social visitor.
Right, and she's saying that she has a privacy interest in her purse and that no one has a right to go through that. Fleming actually appears to do a notice test or apply a notice test under the Iowa Constitution because the district court in that case, and this court upheld it, found that once the police officer was on notice that there were other individuals residing in the house, that they should have stopped and gotten an additional warrant. In addition, it seems like if we applied the possession or the special relationship test, that search would have been allowed. Because certainly as someone who lives in the residence, he has a special connection to the residence. And then he was not in possession. He wasn't even in the room.
Would you agree that Fleming didn't discuss any of these tests? It didn't lay him out. It just talked about the fact he rented the room separately.
I'm out of time. Do you mind if I answer? I think that's correct, but I think the general premise behind Fleming is applicable to this case. Thank you.
Counsel, thank you as well. The case of State versus Brown is now then submitted to the court, and I want to thank again the students for coming into the courtroom this afternoon to be with us, to hear the arguments in this case, as well as thanking the students in other schools from around the state that are watching online. So I know that the students need to leave the courtroom, so we'll sit in recess to allow the students to exit and the counsel to come up and assume the counsel table. We'll be in recess.
Good afternoon. I do have a demonstrative here, and I was thinking I would set it up in front of the empty seat where I would sit after argument. Does that work?
All right, we'll now then hear the arguments in the case Tyler versus Department of Revenue. Mr. Preeb, you may proceed.
Thank you, Your Honor, and may it please the court. Counsel. My name is Eric Preeb, and I'm here with Attorney Dave Dutton on behalf of the protesters in this case, Mark Alcorn and Paula Tyler. This is a case that invokes our guarantee of equal protection of the law under the Iowa Constitution. Iowa's inheritance tax laws discriminate by granting privileges in the form of inheritance tax exemptions to one class of stepchildren, while at the same time imposing a heavy tax on another class. At its core, Iowa's Equal Protection Clause means...
Question, according to Webster's dictionary, a stepchild is a child of one's wife or husband by a former partner. Now, by that definition, Mark and Paula were not stepchildren after Donald was divorced, correct?
I think that's correct. However, that wasn't the operative definition for purposes of inheritance tax prior to the legislature making its enactment in 2003 and dividing up the class of stepchildren. So in this case, we're really looking for a valid reason for treating these different types of stepchildren differently. And we assert the legislature had no valid reason under Iowa's Equal Protection Clause, so we're asking the court to reverse the lower courts and strike the definition of stepchild that's set out in Iowa Code Section 450.1 sub 1E. Now, I think it helps to understand just how the statute works. And the definition itself is set out along with a background at the brief, pages 11 to 14. But consider this, the tax operates by looking at what you can call the horizontal relationship between the parent and the step-parent. But it imposes a tax based on the horizontal relationship, or sorry, the vertical relationship between the step-parent and the stepchild. If, for example, the horizontal relationship between parent and step-parent ends with the death of the step-parent, here in the top example, then a testamentary devise to the stepchild is tax exempt. If the horizontal relationship ends in the death of the parent, again, a testamentary devise is exempt. It's only in this third instance, where the horizontal relationship is terminated by divorce, that the devise from the step-parent to the stepchild is taxed. And in fact, it's taxed at the highest rate, as if this individual was a collateral or unrelated person, almost like a stranger.
But are they still similarly situated once the divorce of the step-parent and parent comes to fruition?
The question of whether they're similarly situated is a difficult one, because remember, the standard is, are these individuals similarly situated with respect to the purposes of the law? And that's from the Racy 2 case, and it's cited by the department. That's problematic because we don't know of a purpose of the law.
I mean, could we say that the purpose of the law is to protect and promote family relationships and families? Isn't that generally the purpose of these kinds of exemptions in different tax laws?
It may be, but I think that's troubling, and this is a rationale that's been explored here through this litigation and by the lower courts. If, in fact, the purpose of this definition and this inheritance tax law is to encourage closeness or a close family relationship, remember, in fact, this statute narrows the tax exemption and imposes more taxes than before. So if the purpose is to incentivize human behavior and to create some kind of a closeness through the tax code, it couldn't do that. It's imposing the tax.
Let's say it's to incentivize people, let's say, you know, we have things like family farms, to keep those family farms within the family. Generally, an exemption that works for lineal descendants would be something that would promote that in, wouldn't it? Isn't that right?
It may well be. But again, part of the problem is you have to ponder why exactly, in this instance, the government has any sort of a legitimate interest in the constellation of a family.
What interest do they argue?
The interest we've seen and explored here in this case, I think there are 8, and for the court's benefit, those are set out one by one, pages 19 to 20 in the brief. The first one that we've addressed is the interest in the purpose of raising tax revenue. Of course, our response here is that that cannot be an answer.
I agree with that one. But the problem I see, and maybe I'm being repetitive, but when you have a divorce, which is in your last scenario, the family structure is now significantly changed. You don't have the kind of the same family structure that you had before when you had the parent and step-parent married, obviously. And could the legislature decide, well, although this is very rough classification, but in those situations, we are not going to assume the tight relationship between the step-parent and the child continues, and we're going to subject it to a different kind of taxation.
I can understand the rationale, however, I don't think it makes sense, and this is why. Remember, if the legislature is acknowledging that the relationship is somehow different, it's imposing a tax where in this one circumstance of the three, the relationship has apparently remained the same. It only taxes, and the statute only operates if there's that dotted line, if there's a bequest.
But divorce changes things in general. I mean, for example, you're not complaining about the fact that the testimony transfers between Donald and Constance are going to get taxed as if they were made to strangers, right?
That's not the issue in this case, that's right.
And I mean, laws don't have to have a perfect fit to meet the demands of the rational basis test. So isn't it reasonable for the legislature to assume that divorce changes things also as to children of the ex-spouse? In many cases, they don't. Apparently not here in terms of the personal affinity between the people, but in many cases they do. Isn't that fair?
It's not exactly comporting with the Equal Protection Clause because, again, it only operates where there is a bequest. Where there isn't, for example, a continuing close relationship, the statute has no effect because there's not a bequest upon which it can operate.
But
Well, to me, again, the entire legal relationships change once you have a divorce, and so you have sort of the benefits are different, and then the consequences are different. And to me, this appears to be, and you have a pretty strong burden to try to overcome a rational basis for the legislature believing that these ought to be taxed differently. And don't you see a difference in the legal relationships that the legislature could also find?
Well, there's a change, but I don't think it's a change that warrants the disparate treatment. Another example, and I think a concern that I'm
But
hearing...
that's kind of a policy argument that you're making. You know, you don't like it and you don't think it's fair, but isn't there a rational basis for doing that just based upon the mere fact that there's now been a complete change in the legal relationship between these people? They're not necessarily, to me, similarly situated any longer.
What the Equal Protection Clause requires, even under rational basis review, is that we assess the means and then the ends to achieve them. And I think the sentiment that I'm hearing from the court has those means and ends backwards. Because we know, for example, individuals are not basing decisions about how they're going to structure their family or how they're going to be close, who they're going to form relationships with, based on incentives in the tax code.
it's not just the incentive argument is one argument, and that's an argument. But it's not just the incentive; it's just preserving the family's wealth, keeping the family financially secure. Now, let's say, as often happens, you had a blended family, and Donald had his own children, and Donald passes. The state might say, well, it's important for us to make sure that Donald's children are taken care of, because and to incentivize Donald to take care of his own children, because Constance's children are going to have a separate family members that are going to be able to take care of them. What's wrong with that?
Well, for one, if you look at this diagram and how the code operates, it has no consideration. It doesn't matter what's happening on the other side of the parent and the child. What else is happening in the family is not taken into
See,
consideration.
you're arguing policy and unfairness, but all the rational basis test under RACI requires is the ordinance serves a legitimate government purpose, which is realistically conceivable, and I think by preserving the family unit and preserving assets that family unit may have developed during their marriage, it's conceivable. Then you have to say whether or not the claimed relationship, the claimed reason has a basis in fact, and in fact, it seems to me it may, for the simple reason it does that, because you don't pay the tax and you may not have to sell the farm. And the third test is it so attenuated, and I don't see it attenuated. So even if you apply the stricter RACI test, I mean, we could talk about what's fair and what's not fair. I mean, it'd be unfair if after this divorce, the biological parent married a millionaire, and the stepkid gets it from the first family and the second family. I mean, we could think of all kinds of things, but that's not the test whether it's fair or not fair. That's what equal protection's about. It's an application of the three-step process, and, you know, apply to me the three-step process and tell me why it doesn't meet rational basis under RACI.
Okay, with the first step, we're talking about, is this a legitimate government interest? And I think the interest we've spent the most time on here this afternoon is fostering a closeness or a certain core of a family unit. That's problematic. If you look at Varnum, for example, one of the first government interests that this court rejected was a certain, what I'll call, constellation of individuals in a family unit.
No, I read completely the opposite. I think Varnum is consistent with this. In other words, Varnum, we said, preserving and protecting the family and assuring the security of the family is such an important interest that it should be available to everybody, whether it's a same-sex relationship or an opposite-sex relationship. Mm-hmm. You don't read Varnum that way?
I don't necessarily disagree with what you've said, but I disagree about the effect of Varnum in this context, because the stepchild in the bottom box there, in the bottom example, and the stepchildren sitting behind me were family, and they were discriminated against based on the inheritance tax code. That's my general response to the first step.
That's the purpose. Now tell me why it's not conceivably in fact.
Is it conceivable, in fact, that this statute would encourage closeness or encourage a certain family unit? Again, I don't think so, because people don't make decisions about who they're close to and who they consider family and who they care about by consulting Iowa Code Chapter 450. The means and ends are backwards.
Let me ask you this. Is there any evidence in the record that the purpose of the statute was simply to raise money and that they just picked the closest target and it was driven by dollars and cents rather than some of these other interests?
There is no legislative history in this case, but the absence of a constitutionally tenable reason and the several years we've spent considering this case lead us to that conclusion, that this was a tax for the purpose of taxing, and that was the reason. And that does not pass constitutional muster.
The tax could have been avoided if he had adopted them, right? What difference how do we factor that into our analysis, or do we?
To answer your first question, yes, I think the tax could have been avoided if the decedent had adopted the stepchildren. The second question of how does it affect our analysis, if at all, I don't think it does, because for a couple reasons. First, yes, adoption is an option that's out there generally in the world under Chapter 600, but it's not an unfettered right. There are barriers to adoption in every case, and the general rule is that adoption begins with termination of parental rights. May I finish, Your Honor?
You may.
The second issue is, and perhaps the more concerning, in all of my research, I have not come across an equal protection case where the parties in the court agreed the statute violated the Equal Protection Clause, but nonetheless it was preserved because basically the bar could contract around the statute. I think that's what you'd be facing here. Thank you.
Mr. Preet, thank you as well. Mr. Stanley.
Thank you. May it please the court. I think it's best to start with an overall big picture of the case. As Mr. Preeb said, the appellants are challenging the inheritance tax code, which is based on close legal relationships, that is by blood, by adoption, or by marriage. And they're saying in the marriage context, by not allowing stepchildren to inherit without tax if the marriage has been severed by divorce, they're being discriminated against, or
Well,
there's a
Mr.
violation.
Stanley, is it really close legal relationships or just legal relationships?
Well, I
Is
think
the
it's,
state interested in the closeness if if the legal relationship exists?
well, I think that's where some of the confusion in the case lies. It's not close in a personal way. It's that it's a close legal relationship, or the people who inherit without tax, and that is the children that are biological or adopted or by marriage. And I think I can maybe get to your point by making a couple of comments about the easel. We agree that these are accurate. We don't agree on the interpretation. In the first two, before there is an inheritance because of a passing of one of the parents, the marriage is intact. On the third one, before there's an inheritance because of a passing of the parents, the marriage has already been dissolved. And that's why that chart is right, but the interpretation is wrong. The other thing that I think is really important about it, and is why I talk about a close legal relationship, is we agree with all the words on the third part except tax as if unrelated. Because under the Iowa Code, these stepchildren from the divorced marriage are taxed just as Justice Mansfield said. The ex-spouse who got 23% in this case, she was taxed at this rate. If you have nieces, nephews, cousins, aunts and uncles, all of those people are taxed at this same rate, as well as strangers. So you don't have to be unrelated to be taxed in that way. There are a lot of people who are related. They're just not as close a relative as are children by biological adoption or during the marriage.
If you were to go through the RACI analysis, I think it's 3 steps, some people say it's 4, but if you go through the RACI analysis, how can we uphold this on a heightened rational basis test that we apply under the Iowa Constitution?
Well, I think we would say that this is just a regular rational basis test, but even under RACI, there are several grounds that we argued, not 8, because some of these grounds are intertwined, and we've always said there were 4, and then one of the things they've done is say they're 8 and cut them in half.
Let me maybe tell you my concern. The first one, I think, as we set forth in RACI, you must not ask whether the ordinance serves a legitimate government purpose, but also whether the claim state interest is realistically conceivable under that purpose. So what's the purpose, and is it realistically conceivable?
The purpose, one purpose, and I think that's the one you've talked about the most, is the incentive to save and invest and to pass on the assets, whether it's a business or money or a farm or something like that, to the lineal descendants. Another purpose is not just to raise revenue. We've never claimed that that was a purpose in and of itself, but to raise revenue while having an equitable tax burden. And in this case, the legislature made a decision. It was equitable to have the people by the descendants by biological means, by blood, by adoption, and by marriage. It was a fair burden to have them get this exemption. Because of cases like blended families, like Justice Mansfield said, other things, to put them on parity and help out, those people all have the same. But when the marriage is broken, And I think this is where we get into the similarly situated argument, where I know I tread a little dangerously, but, you know, it was true in Timberland, and I think it's true here, because in this case, the children are more in the same boat as unmarried people that might live together and have children, care for the children care for them, but there isn't a legal relationship any longer. An aunt and uncle
And
would take
when you
care
go to
of
the next step, does the reason for treating these differently have a basis in fact? I mean, have you shown that?
I think that's what I was getting into, was that, and this is, you know, the analysis from Varnum, that really similarly situated merges into the legitimacy consideration. And I think it's true because they have a different relationship now. They don't have the marriage bond, so they're more similar to families where there isn't a marriage. They're more similar to the aunt and uncle who may take in a nephew or a niece and give them great care and have great personal relationship. But I think the overall view of this case that I think is the most telling is that the whole discrimination theory is based on the fact that the current law doesn't consider the closeness, the enduring personal closeness that you have after the marriage is over. And the problem with that, and the remedy they propose, is they propose the remedy of once a stepchild, always a stepchild. And that, again, just like the law they're challenging, doesn't consider closeness at all. It's another bright line test. And in inheritance tax, it's helpful to have these bright line objective tests, because that gets to some of the other purposes that we talk about in our briefs. The uniform administration of this, the burden. If we had to go on every will and see, is there a close, enduring relationship, and that's the reason you get to inherit tax-free, that's an insurmountable burden for the state.
You got me there, no question. But I think it's fair to say that the other side in this case focuses not so much on the marriage relationship, but focuses on parent, stepchild, parent, stepchild, parent, stepchild. And the other side might well be willing to concede that you shouldn't have an individualized showing. They just think the rule ought to be different. And that they're really, because these relationships are so varied, and you know, there's the kaleidoscope of relationships between parent and step-parent is varied. Because they're so varied, the simple thing to do is say, treat them the same all the time, anywhere, any place, court adjourned. And the notion that the relationship is affected by a derivative relationship, that mom and, you know, that the people aren't married, that in real life, that isn't necessarily true.
Well, I think it's reasonable for the legislature to believe, again, as Justice Mansfield was saying, that after the marriage is dissolved, there's a chance that, you know, where this could be the case with Ms. Tyler and Mr. Alcorn, we're not challenging that in their case. But as we cited a lot of cases, and in the Mueller case, for instance, it put out the caution that courts don't make determinations about inheritance tax and constitutionality on the basis of an ad hoc example. It's a
But is
policy.
it, okay, let me try this. Is it rational to believe that if there's a divorce, as there is in situation 3, that therefore there must be a change in the relationship between the parent and the stepchild? Is that, I mean, it's obviously not a one-to-one relationship, but I mean, I think the basic rationale that I hear you saying is that if the parent and step-parent get divorced, that, for purposes of this statute, automatically means clear rule, that the relationship between the parent and stepchild has been changed.
Well, no, I'm not saying that that happens in every case.
I know you're not saying in every case, but is it even rational to assume, it may be overbroad and under-inclusive, but is it rational to say that a divorce, is it rational to say that we are going to treat the stepchildren differently in every instance where there's a divorce? Is that, I mean, it doesn't have to be a perfect fit, and we know all that, but is it a reasonable fit to say that when a divorce comes along, the stepchildren, for purposes of inheritance tax, are in a separate class?
I think for all of the reasons that we give, and some of them may be a tighter fit in reality than others, but I think the fact that the legislature could believe this is a rational reason for doing it, and it does have some basis in fact, and the fact that the code now isn't based on that personal affinity. There are biological children that don't get along with their parents. There are adopted children that don't get along with the parents during the marriage time. That it could be both ways, and so it was reasonable that they do that. It's just that the legislature has chosen to make it a more close.
I mean, wouldn't it be fair to say that, I mean, the legislature is going to have to make, there are really three options, right? I mean, one is the assumption that divorce changes things. One is the assumption that divorce changes nothing. And then the middle is a case by case. And the legislature picked one of the three. I think I'm the only one on this court, by the way, who has a blended family. So if I was asking questions, that may be why.
Well, and I came from a blended family, but what it does is, you're right, you have to pick one of those three. And as Justice Sager said, there's a heavy burden here to negate all of this beyond a reasonable doubt. And I don't think it makes no difference at all over, it does make a difference. The appellants have met that standard at all. And what I'm saying is that if you just look at the closeness, that is administratively untenable. There's no way that we can get into every probate action and look to see if closeness is the test. And I think that's why, even though they argue closeness is the problem, their test, their remedy doesn't consider closeness at all. It just is another bright line test. And we have those all the time in inheritance tax. We have them on family settlements, the live-in case. We have them on these kind of issues where you have a bright line test because that's what you can administer. I do want to, and I think we've talked about them a little bit, but in the reply brief, there are two new issues. One is this close relationship versus close legal relationship, and I think that did get a little muddled as we went through, but part of this is there is a inversion of the causal relationship. This inheritance tax benefit was instituted to help encourage close relationships. It's not a reward for having a close relationship. That wasn't the purpose of the statute. And secondly, about the similarly situated. And I think not only we have a dictionary definition, but we have other parts of the code, and this was part of the district court ruling too, where in section 252, A2 and A3 talk about the financial obligations during the marriage that a step-parent has. And in section 600 talks about the responsibilities and the rights of a step-parent during the marriage. And so that's why I say this is a little like timberland, because even though the apartments and the condos looked exactly alike, the decision was based on the bundle of rights that you have from the fee simple interest in the condo as opposed to the rights you have renting an apartment. And I think a step-parent during a marriage has certain rights and responsibilities that they don't have afterwards. And so the step-parent-child relationship is changed after there's a dissolution in the marriage. I think, you know, aside from this, we just stand on our briefs. Thank you.
Mr. Stanley, thank you as well. Mr. Dutton.
May it please the court. Counsel, in 1997, the Iowa legislature reinstated the inheritance tax exemption for stepchildren. And the Department of Revenue
They
determined-
reinstated, but Mr. Dutton, they reinstated it for everybody. Prior to that time, the only exemption was surviving spouse, right?
Well, that's correct, but the last time the Iowa legislature had given stepchildren an exemption from inheritance tax was 1911. So this was a dramatic act, and it was precipitated by the fact that farm income had reached a historic high in 1997. And as we know, in Iowa, the farm economy drives the legislature in terms of its ability to fund the government. And after the amendment was granted, and stepchildren now of all kinds were granted the exemption, the Department of Revenue said, we will not discriminate as to stepchildren whose parents have died, as opposed to stepchildren whose parents are divorced. In other words, across the board, they would grant exemptions for all stepchildren based upon their understanding of the law. In 2003, unfortunately, the farm income declined to a point where the Republican House and Senate were scrambling to find revenue for the government. So one of the things they looked for was some revenue source, and the closest one they found was the stepchild and the stepchild exemption. And that's what they keyed on in getting revenue back for the government so they wouldn't have to come out and say, we've increased taxes. And we know that's something that the legislature would hate to admit. So what they did is they simply redefined stepchild to exclude from that inheritance tax those stepchildren who had, in fact, parents who had been divorced. And the reason they picked on that particular exemption is that there is a bias in this state and in the world, actually, against stepchildren. That's a pejorative term that is applied to a lot of people, mostly by biological children who think they're somehow superior, based upon the myth developed by Cinderella and all of the ideas that the stepmother is an evil person and that the stepchildren are punished simply because they have fallen into her grasp. But the other thing that's most important here in terms of the mental attitude of the legislature is that until recently, and in fact still, there are religious groups that are prominent in this state who believe that divorce is a sin and that remarriage is adultery because in the eyes of their God, you have not actually been divorced. So this was a very easy fix for the legislature to simply say, we no longer will grant an inheritance tax exemption when the parents have been divorced. And they would seal that by saying, and quoting scripture, that the sins of the father are visited upon the children from generation to generation. Now, those statements we grow up with, we were taught, and that means that the legislature had those beliefs that would undercut and support that division. And what you're faced with here is whether or not that is a rational basis for distinguishing between stepchildren whose biological parent died and stepchildren whose parents were divorced. And I believe, and I think you can find that that is an irrational argument and an irrational basis upon which to make that distinction.
But counsel, if there's a problem with stepchildren not getting along with biological children or a bias against them in blended families. Isn't this a good thing to allow a financial benefit for when the step-parent and other parent remain married? They keep that family intact, and that's supposedly one of the purposes of this exemption, that it promotes that family cohesiveness.
Absolutely, and that's the Brady Bunch example that now I think leads the fact that there are 1,300 blended families that occur every day in this country, every day. And there will soon be more blended families than there are families that are not blended in our society. So this is something that is a part of the reality that we're faced with and we're going to have to deal with. And this is not the point at which we say we're going to go old school and we're going to punish these adopted or these stepchildren because of the sins of their parents, i.e. that they got divorced. That's wrong-headed, and it's not right, and it's not constitutional. Thank you very much.
Mr. Dutton, thank you as well. Case of Paula Tyler versus Department of Revenue is now then submitted to the court, and the bailiff may adjourn.